2025. It is 5:30 p.m. Washington time, and you are watching Lawfare Live, the Now. I'm Benjamin Wittes, editor-in-chief of Lawfare, and I'm here with Lawfare senior editor Roger Parloff to talk about a truly extraordinary document that I think it is fair to say that none of us was quite anticipating today. It is a opinion by Magistrate Judge William Fitzpatrick, which I believe makes this the first ever Lawfare Live devoted entirely to an opinion by a magistrate judge. It is 24 pages long, and it orders the disclosure of the grand jury transcripts and minutes to James Comey's lawyers, his defense team. And while that is not a total surprise, given that the magistrate had suggested earlier that he wanted to do that, and it had kind of been sent back to him for more particularized fact finding. What is, at least to me, a mostly total surprise is the scope, range, and ferocity of the fact finding that Magistrate Judge Fitzpatrick made about Lindsay Halligan, the U.S. attorney in the Eastern District of Virginia, and the at least one of the FBI agents who worked on this matter. So, Roger, let's briefly go back over how we ended up with a case in front of a magistrate judge about the transcripts of the grand jury material, the grand jury proceedings involving former FBI Director Comey, and then let's talk about what's in this crazy opinion.
Yeah, this seemed to be a real side issue when it first arose. The government asked for something called a filter protocol, indicating that it had a pile of documents that it had obtained from a search, and it was vague about what the search was. And there were some potentially attorney-client privilege in there, and they wanted to go through and the proper way with a cordoned off team and check for attorney-client privilege. And Comey said, wait, hold on. We're not there yet. We think there's a lot of problems with this pile of materials you have. We need to first, we may need to make a motion to suppress. There may be Fourth Amendment issues. There's other attorney-client issues already. We want to know a lot more. And then there was some proceedings. That's why the Judge Nachmanoff sent it to the magistrate to try to hash these out.
Roger, was it just me? You've actually practiced law. I never have. When I saw that there was a motion for a filter protocol, I thought, okay, boring, normal uh, defensive lawyering on the part of the government. Just make sure that all the I's are dotted and the T's are crossed, and you can use all your information. I barely read the initial motion and Comey's initial response. I thought it was way less interesting than, say, the motions to dismiss that they were filing concurrently. Was I just being like thick-headed, or was this a real sleeper?
Well, the thing that
Or both?
uh, the I mean, I can't pretend to lots of experience with Fourth Amendment issues like this. The thing that stood out was that why are they doing this now? I mean, if there's a problem, filter. I mean, you've got an indictment already. Why? If there you want to go through search materials now, why are you doing it now? So it did seem, as the magistrate later said, very annoyed at one of the hearings. Indict first, investigate second. There was that obvious on its face, but other than that, it sounded highly arcane, and I wasn't expecting it to develop the way it has.
All right. So let's leave aside the procedural machinations that got us here, which involved a previous order, a trip to the district court, and then a kind of a remand to the magistrate judge. There's a some briefing. There's a hearing last week, which was brief and frankly did not prepare me for this. I read the transcript of it. I did not remotely prepare me for this opinion. What is the bottom line of this opinion? And then let's unpack some of the details.
So remember, of course, he did order these grand jury minutes turned over last week. And so Judge Nachmanoff said, well, make some particularized findings. The government objected and said he made no particularized findings. And so Nachmanoff said, okay, make some particularized findings. And boy, did Fitzpatrick deliver on the particularized findings. So the issues that we thought he was dealing with, and which he is dealing with, are Fourth Amendment and privilege issues. And they stem from, there were four search warrants issued in 2019 and 2020, that's 5 and 6 years ago, to look at Dan Richman's, the Columbia law professors, to look at his various devices. And they were looking at that time, that was the Arctic Hayes investigation, they were looking for different crimes than they are looking now. One was a sort of a Espionage Act, retention of, willful retention of classified information. One was taking federal property, and those are different crimes. And so one issue is whether the people back then did things correctly, because apparently they didn't. You know, like one of the warrants said, don't use X. And so you needed to separate out from the materials you got X and not X. So that's called a responsiveness review. Apparently that was not performed, at least with all of these. Also, there were the privilege, they were looking for privilege issues, but for Danny Richman's privilege, because he had his own lawyer. They weren't looking for Comey's privilege.
And there were particularity issues. When you have a warrant that says you can seize X, Y, and Z, that means you can't seize A, B, and C. And
that's what I mean about responsiveness, that they were supposed to do this, make sure they were seizing only the responsive stuff and sealing the rest so that it wouldn't be used. And then the other half of it was more recent, what happened in 2019, September 2019, when they started rummaging around these materials. And Comey was saying, you need a search warrant. It's 5 and 6 years old. You're looking at a different possible defendant. You're looking at different crimes. You can't just rummage through these old materials. And so, and basically, and then also the new, one of the new team, an FBI agent, he was tasked with taking all these materials and separating out the Comey-Richmond conversations. He does that. That's Agent 1. He gives them to Agent 2, and Agent 2 begins to read them. Agent 2 realizes, gee, some of these look privileged. And then, so he alerts Agent 3 and gives him what's called something like a limited overview of what the privilege issues are, and he also notifies the general counsel of the FBI. Agent 3, even though he has received that limited review, is the agent who goes before the grand jury, the only one. He's the only witness. And so ordinarily, that's not what you do, apparently, at least according to Fitzpatrick, Magistrate Judge Fitzpatrick, who is very worried about. So those are the Fourth Amendment issues, which deal both with what happened in 2019, 2020, and what happened in September 2025.
right. So all of that would have been interesting enough. But then,
Dianu.
right, but then they don't stop. The Fitzpatrick doesn't stop with a set of Fourth Amendment concerns or privilege concerns. Uh, he goes on to talk about the prosecutor, by which he is clearly referring to Lindsay Halligan, though he doesn't name her, I think, um, her conduct in front of the grand jury. So tell us a little bit about what he finds, and there are some redactions that make it a little bit unclear, but only a little bit unclear what he's suggesting here. What did he find about what Lindsay Halligan did?
Yeah, so I'll just read one of the money lines. There's multiple money lines in this thing. The court has identified two statements by the prosecutor to the grand jurors that on their face appear to be fundamental misstatements of law that could compromise the integrity of the grand jury process. Both are in response to questions by grand jurors and are directly related to communications involving Comey.
Important for viewers to understand this, that the prosecutor is actually formally the legal advisor to the grand jury. So when a magistrate judge says giving you're giving false law to the grand jury, it is hard to understand how the grand jury is supposed to do its job when its legal advisor is misinforming it. So, what do we know about the two statements that she made that are not correct as a matter of law?
The first statement, judge, the magistrate judge thought seemed to violate Comey's Fifth Amendment right to remain silent. You know, the defendant at trial does not need to come forward and say anything. The government needs to prove its case. That's sort of fundamental. So apparently a grand juror asked a question, she responded, and the magistrate judge thought that response violated that Fifth Amendment principle. What he said was, grand jurors may have reasonably understood the prosecutor to mean that if she could not satisfactorily answer their questions, then Mr. Comey would, redacted, answer these questions at trial. So I don't
And
know if
what's wrong with that?
and the
As,
redacted is very short. So it might have been something like, this is pure speculation, but Mr. Comey would need to answer these questions or have to answer these questions or have an opportunity to. That's too long, but anyway.
but what is wrong with saying, let's say, would answer or would have to answer or would be asked this at trial?
Because
What
it's
is wrong with that?
Yeah, it's fundamental that the defendant's silence cannot be used against him at trial. The fact that he chooses not to testify can't be used against him at trial. So the government always bears the burden of proof at every stage. So you can't imply that by not coming forward or that he has to say anything.
All right, what's the second one?
The second statement he described as it clearly suggested to the grand jury that they did not have to rely on the record before them to determine probable cause, but could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. And again, that entire sentence, whatever it was redacted, so we don't have any clues.
And again, what is wrong with that?
Well, you can't say to the grand jurors, trust me, we've got it. We've got the goods on him. The whole point is to come forward and prove probable cause. So right there before them.
Yeah, and I think you're really not allowed to say, please indict on the basis of evidence I'm not going to present to you.
Yeah,
It's,
but I tell you, it's really good what we've
it's
got.
hot. Um, all right, so again, Dianu, we've got more. So it turns out that the magistrate judge has some doubts as to whether the government gave him the whole transcript and the whole audio. What is that about?
Yeah, and if it did, there's still problems. And this was something that tripped up Judge Curry on Thursday of last week. She was troubled by the same thing, and it also tripped up the original magistrate, when this was handed up. There was this weird process where, remember, the original charging document had 3 charges, and then apparently the grand jurors, well, it's still unclear. Apparently the grand jurors said no, and then, but they were willing to indict on the second, this count 2 and 3 of that. And then a new charging document was created and they apparently indicted. The problem is this, that the, the minutes stop at 4:28 p.m. And don't resume until, and then Halligan has filed an affidavit saying they don't resume until 6:47. And Halligan has said they were deliberating for 2 hours, which is quite unusual apparently for a grand jury. A very experienced federal prosecutor told me he has never, ever seen that. But
Grand jury deliberations are normally quick because the evidence normally so exceeds the standard of probable cause because prosecutors are thinking about proof beyond a reasonable doubt, and so they over present, and it takes grand juries very little time to indict.
yeah, but it could be, especially because we also know that it was only 14 whoever, out of a possible maximum of 23, whoever did find there was probable cause. So maybe there was quite an argument in the grand jury. But anyway, what Halligan has said is that at 6:40 p.m. she was notified by the first assistant U.S. Attorney Maggie Cleary, who I think has she been fired now, or she's no longer there for whatever reason, that the grand jury had presented a true bill as to counts 2 and 3, but not count 1. And then the hearing starts again at 6:47. And what the magistrate judge is saying, that's not enough time to draft a second indictment, present it to the grand jury, provide legal instructions, give an opportunity to deliberate, and then render a decision on the second indictment. And that if that didn't happen, he said, the court is in uncharted legal territory, I'm quoting now, in that the indictment returned in open court was not the same charging document presented to and deliberated upon by the grand jury. That calls into question the regularity generally associated with grand jury proceedings, provides another general issue the defense may raise. And one thing we have known since day one is that there's something funny about the 2 documents. There's there is in the docket what is said to be the first indictment, the one that was no true build. And it has count 1, which was no true build, count 2, but then the page 3 is obviously not page 3 of that original document. It's page 2 of the current indictment. And you can tell because the page number is wrong, the paragraph number is wrong. And by the way, Empty Wheel has explored all of this long before I did. So that has been in the back, of everyone's mind for a long time. What was that about? And it seems like we still haven't quite gotten to the bottom of it.
Yeah. And it seems like even looking at the grand jury transcript, the magistrate judge can't get to the bottom of it. And he's clearly suspicious as
And
a result.
Judge Curry was also. She thought something was missing.
Yeah. So, all right. So what else we got?
At that point, he delivers the findings. There are 11 of them. They're pretty scorching. Um,
And
uh,
these are just findings of fact, right? I mean, there's no legal conclusion here except that Jim Comey gets the grand jury transcripts, right? These are just accounts of what he regards as found fact as to the current state of the record. Is that right?
yeah, facts that would warrant um, turning them over to the defense team, uh, which isn't usually permitted until you know right before the trial. They get the before a witness testifies, they get that witness's testimony. But uh, you wouldn't get these, and there are other confidentiality considerations that ordinarily um, weigh against disclosure. So he's saying here are things that overcome that those confidential that ordinary assumption that we ought to keep this confidential because the defense really needs to be able to explore something.
And the logic, as I understand it, is that the defense may have a plausible motion to dismiss on the basis of any of these or some combination of these factors, and therefore they need to be able to see the record in order to make that argument. Is
That's
that?
exactly. He's not saying I find as a fact there's a Fourth Amendment issue. He's saying it looks like the defense could raise a colorable Fourth Amendment issue, maybe more than colorable, and it warrants showing them what happened here.
So we have not yet heard from the defense in terms of what it makes of any of these findings or what motions it will or will not file. I assume that they will be in court presently informing Judge Nachmanoff that they have some additional motions to dismiss to file. Do you share that assumption?
Well, yes, and actually, the uh, Judge Fitzpatrick has set a date, and I don't have it in front of me. November. It's in November for Comey to file, if he's going to file a motion to suppress. And I think that would also include the privilege issues as well. They don't have time I think, so we know that will be coming. Whether this will be loaded into another sort of outrageous misconduct motion, which he had also previewed he might be filing, that I don't know.
Yeah, although, I mean, there's another possible argument, which is that if you suppress enough of the information merely based on, the government is proceeding on the basis of a whole bunch of emails and text messages that are taken from this body of material, if you suppress that stuff on grounds that either it was privileged or more plausibly that there was something defective about the search, at least the second search,
Yeah,
you could really end up with a situation in which the case hasn't been dismissed, but the government has no basis on which to proceed, right?
that's right. That's exactly right. And now a Fourth Amendment search, you have to show not just that it was unconstitutional, but that it was sort of willful or reckless disregard for his um, uh,
His
constitutional
rights.
rights. And
Yeah, but the judge
here,
here indicates
yeah,
something about that because he really, points out that they didn't consider any of these matters because they opened the investigation with 18 days to go before the statute of limitations. And he doesn't say that that was why, but he sure does imply it.
Yeah, I think that's right. That might give the willfulness, the recklessness, the fact that this is a mad dash to get in under the line and of the statute of limitations, and also to get over the hurdle that no career prosecutor will touch this.
All right, so we haven't heard from Comey's team yet about this. We will, in either in the form of a suppression motion, an outrageous government conduct motion, or a simply an additional motion that there's something defective about the grand jury process here because the grand jury was misinformed as to important questions of law. I suspect we're going to get something as well about the this missing, the it's like the Rosemary Woods missing minutes in the in the Watergate tapes. Um, but we have heard from the government. What was the
Well,
government's response to this ruling?
um, the government has filed an emergency motion to stay before Nachmanoff. You know, you can appeal basically a magistrate's ruling to the judge. And so they filed that. Um, as of this recording, I have not seen any ruling come up on the docket. And the deadline that Fitzpatrick gave was 3 o'clock today for the transcripts and 5 o'clock today for the minutes. So I don't know what the status of that is. Also, we did get, and I don't know if this is related, and I haven't, I've just skimmed it. We also did get a motion to disclose grand jury records from James today, Letitia James.
Why not get in on a good thing?
Yeah. And hers is much narrower. She only wants 4 narrow categories. And I don't know if she cites this decision or whether that was already in the works.
All right. What have I
Oh,
neglected to ask you, Roger?
no, uh, I think those are the key things. I think those are the key things.
All right, folks, we were completely not anticipating having a Lawfare Live the now today. We've got a whole lot of hearings coming up this week. We've got hearings we've got briefs due in the James case. We've got a hearing in the Comey case. We've got uh, whatever surprise rulings are going to come down. We also have briefs, a reply brief or two due in the Comey case. So we may be back tomorrow, Wednesday, Thursday, and of course we will be here for Lawfare Live on Friday at 4. Keep your eye on notices of additional spot live streams that we may do because things are happening very fast now, and we are committed to keeping you as informed as we can.
You know, yeah, that was a great ending, but I just something occurred to me that is sort of important. A lot of attention now goes to this statute, 18 USC 3288, which is ordinarily if you file an indictment and then there's litigation and the indictment is dismissed, but without prejudice. 3288 says the government has 6 more months, calendar months, to indict again. And so there's going to be a lot of dispute about whether that can be applied here, because it's looking increasingly like this indictment cannot survive. And so there's going to be questions, well, is it null and void? And so the statute of limitations ran out September 30th, or did it stay the statute and now they get the benefit? So there'll be a lot of litigation over that. Sorry to.
Yeah, no, it's a really important point. And Fitzgerald, as distinct from Fitzpatrick, Pat Fitzgerald is Jim Comey's lawyer, has been hammering this point in a different context, which is the context of whether Lindsay Halligan was illegally appointed. And the context there is, if the court, and this is Judge Curry, right, were to rule that she was not lawfully appointed, um, then normally you would have a dismissal without prejudice, which would buy them an extra 6 months, having installed her quickly to avoid, to get over a 3 day problem.
Hmm.
And so Fitzgerald's argument is you shouldn't give them a 6 month windfall for acting illegally.
Right.
I think this is one of the key things to watch as Judge Curry heads toward a ruling, which I believe she said she was going to rule before Thanksgiving, right?
That's right. That's her aim.
So again, within the next few days, we're going to have a ruling, and this would be a consolidated ruling for both the James and Comey cases as to whether both of these indictments are defective for having been brought by Lindsay Halligan, who is allegedly unlawfully appointed. So a lot of stuff happening. Keep your eye on Lawfare for written evaluation. Keep your eye on this channel for spoken word evaluation, and we
Can,
will be
and can I plug something? There, just
pleased.
today, I published on Lawfare the uh, a dispatch about that unlawful appointment hearing from Thursday. Very
Right.
detailed. If you really wanna go into it, it's there.
If you want the top line half-hour version, we got you covered right here. If you want a really the dispatch version that's almost like reading the transcript, except you don't have to read a transcript, Roger's got you covered on the site. We will be back. I suspect it's going to be real soon.